religious accommodations in the public good, or religious accommodations in the common good. And it's a 10-page paper that just goes through some of the history of accommodations for public employees. And that this is something that we never before in the character said, do your job or quit or go to jail. And so why are we now doing it on this issue? We've accommodated police officers who were assigned to protect abortion clinics, asked to be reassigned to some other patrol. And provided they do it ahead of time, right? Look, if the Planned Parenthood clinic is being robbed, you have to respond if you're a first responder. But if it's simply a matter of where are you going to be assigned for routine patrol, if half of the police officers are pro-choice, and half are like, couldn't you assign one of the pro? I mean, so there are simple ways. And Title VII of the Civil Rights Act actually requires religious accommodations for all employees, both public and private, with the exception of elected officials. That's why Kim Davis wasn't protected under Title VII. So, I mean, yeah, do you want to follow up? Or?
Yes, sir, just one follow-up.
Yeah.
That was my next question, actually. The system that you have here, and you talked about the North Carolina rule. I was wondering how that would happen. Let's say that the entire office declared a religious exemption.
Yep.
Would it then fall to the elected official in that circumstance?
So I think, I'm trying to remember how North Carolina works it out, but I mean, I think in that situation, then they would say, well, there is no reasonable accommodation, right? Someone in the office has to be issuing the marriage licenses. And so it may be that whoever is the supervisor for that office would say, we're going to have to let one of you go so we can hire someone else who would be on this. So it's unclear kind of, what the precise mechanism is. But the kind of operating principle is you want to accommodate as many as you can. But that obviously means someone in each office has to be able to do this. And actually, if I remember now correctly, and I think this is correct, they were actually having county clerks from a neighboring county come into one of the counties where there wasn't someone able to do that. And so they were actually driving so that they would be able to issue the license. And I think that's one of the things that now the left is challenging, saying, well, that's now burdening the clerk from the neighboring county who now has to drive 20 minutes to the other option. You've increased, their commute. Who knows? Maybe they're compensating them for the commute. Maybe they're being paid for the traffic. I don't know, but my only point would be we want to try to find a way to find an outcome where both sides can win, rather than making it a winner-takes-all situation. And the fact that so many leaders were unwilling to even look for these solutions, I think tells us a lot about what we're up against. Mm-hmm. Yep, in the front.
There is going to be no solution that will make both sides happy, because the other side is going to push and push and push. You give them one accommodation, they're going to push for 10 more.
Some on the other side. So here's here's what I take to be the reality on these sorts of issues. You have very loud, vocal, prominent activists and ideologues on the left who are not representative of the majority of liberal Americans. So the majority of liberal Americans who are in favor of gay marriage are not in favor of fining that Baker family $135,000. The ideologues and the activists are, but ordinary Americans aren't. If you're an ordinary American who is in favor of gay marriage, chances are you have an aunt or an uncle, a mom or a dad, a brother or a sister who disagrees with you. And most of them aren't willing to say, oh yeah, my mom, she's Hitler reincarnated. She should go to jail like Kim Davis, right? The activists, the ideologues, there's people who are kind of like cocoons of a certain liberal ideology where they can reach that conclusion. But most Americans aren't there. So I think our challenge is actually to try to appeal not to the activists and ideologues on the left, but to the reasonable liberals, and say who actually speaks for you better. Are your own self-declared leaders actually representing your viewpoint, or is this bill that I'm suggesting and defending a better representative of liberal values? That this is actually protecting diversity and tolerance and pluralism and all of those things that you yourself say you support. I think that's what we have to do, and then if we're successful at that, then there can be a way in which the ideologues won't be happy, but maybe 70, 80% of Americans will be happy. And that's a much better outcome then ceding the ground to the most vocal and kind of prominent voices. And right next door, yeah.
That the Supreme Court is not the final voice. They don't have the final say. So I'm wondering, why as constitutional citizens are we putting up with the judiciary making laws?
Yeah.
What can we do now that they've created a law for us to follow that's unconstitutional?
Yeah. The most practical solution to this is to say that whoever appoints the next Supreme Court justices, it's to settle that issue. Think about it this way. On Inauguration Day of 2017, so we'll have a vote in exactly a year, and then in January of 2017, someone will be inaugurated president. On that day, there will be 4 Supreme Court justices in their 80s. That next president, and the 4 are Scalia, Ginsburg, Kennedy, and Breyer. So it's 2 liberals, 1 conservative, and the swing voter. Whoever gets to appoint those next Supreme Court justices gets to reshape that court. And so again, elections have consequences. And so this could be a reason for all of us to be engaged in the political process as citizens to say that whoever gets to appoint, and then in the Senate, whoever gets to confirm or block confirmation of those justices. Because unfortunately right now, there isn't the political will to do what Abraham Lincoln did to the Supreme Court after the Dred Scott decision. Right? So the Supreme Court in Dred Scott said African Americans can't be citizens, and that's why Mr. Dred Scott doesn't have standing to sue in this court. And Lincoln says, all right, I have to respect the Supreme Court on the particular litigants and the particular case before them, but I don't have to accept their interpretation of the Constitution. And so Lincoln instructed federal officials to issue passports and patents to African Americans, precisely to recognize them as citizens in defiance of the Supreme Court's ruling. There is no appetite for that among political leaders today. So the practical, I think the best we can hope for, George W. Bush appointed 2 Supreme Court justices. They both voted to uphold the authority of states to make their own marriage laws. President Obama appointed 2 Supreme Court justices. They both voted to strike down those laws. Whoever appoints these future Supreme Court justices, I think that's our most practical hope. Yep.
So, on the idea of elections having consequences, 2 things come to mind. First of all, for the elected officials in the room today, thank you very much for being here. It's powerful, I think, for us to see you here. What's going on in this particular meeting. Second is to put you on the spot just a little bit. Elections have consequences. On the specific issue of religious liberties, of all the candidates out there right now, could you give me just a quick 1, 2, 3 of those who most intricately understand the issues and they have the willingness or ability to fight this?
Sure. I mean, so my understanding is that all of the senators who are running for president are co-sponsors of the First Amendment Defense Act. I believe that's accurate. Is that
you mean Lee's bill?
Lee's bill? They're co-sponsors of the Lee bill. My understanding is that Cruz, Rubio, and Rand Paul are all co-sponsors of that bill. So that would be one indication. Obviously, Rick Santorum has a long history of caring about these issues. Governor Jindal in Louisiana issued an executive order protecting religious liberty in the aftermath of the Supreme Court's ruling, so he has a good track record on these issues. Jeb Bush seems to understand it, just based upon things that he said. He had that great line in one of his speeches when he says, you know, if it's a choice between the Little Sisters and Big Brother, I stand with the Little Sisters. It's a good rhetorical line. I mean, my personal thought is that Carson and Trump aren't going to be the nominees. If these are going to go and then fold. And so it's probably going to come down to Rubio and Cruz. This is just my personal opinion. And I think they're both good on religious liberty, from what I can tell. they have track records in the Senate. They're co-sponsors of that bill. Yeah, in the back.
Thank you. So one of the things I suspect is going to happen in our legislation this year is probably going to be a push to conform our state statutes that define marriage between a man and a woman to conform to the Supreme Court ruling, which I have some issues with. Number one, the judiciary branch doesn't have the power to codify law. It's not codified in federal law or state law, so there's nothing there in writing. But and I wasn't here the first part of your seminar, so I guess is talking about fighting back. One of my thoughts is that there is this push to change our laws, that the legislators stand up and say no. And despite what the Supreme Court has ruled, the state of Wyoming is going to keep the state. Know your thoughts on that? If you think that would be a good idea, if you think that would backfire, or if there's
So I think that's the Lincoln strategy. So there's a statement that's been put out by Robbie George and about 50 constitutional law scholars that calls for exactly that sort of a response. It's put up by the American Principles Project. And so if you do a Google search for American Principles Projects, Robert George, and something like resistance, I forget, you can find the statement. And they've been advocating that this is what Lincoln did to respond to Dred Scott, and that we need something similar. Wyoming might be exceptional in this context, but otherwise, I haven't found a critical mass of political leaders willing to actually do it. And it's the type of thing where if you don't have enough support, it will end up probably backfiring. That it'll cause more harm than good if it's a failed attempt. And within the political chattering class, what's interesting, the journalists, they don't understand this at all. Like when they hear about this, they think it's treason. You know, they think that that you would be engaged in anti-constitutional activities. They're like, of course, whatever the Supreme Court says just is what the Constitution means. Like they don't get the difference between constitutional supremacy and judicial supremacy. And that judicial review is legitimate, right? The Supreme Court gets to review both laws that are passed and cases, but they don't get to say what the Constitution itself means. And there's a difference between judicial review and judicial supremacy, and that all three branches of government are co-equal when it comes to upholding and defending the Constitution. And the state. So it's the three branches of the federal government and the 50 states are all co-equal in saying what the Constitution means. And that what they pledge allegiance to is not the Supreme Court's interpretation of the Constitution, but the actual Constitution. Again, because of our poor education system, most Americans don't understand that. And if they started hearing it now, they would think you were the crazy one. And so that's just the risk. So I mean, my personal kind of like prudential judgment is that we're on surer footing if we're talking about protecting our freedoms from government coercion. So something like the First Amendment Defense Act or the Religious Freedom Restoration Act, those sorts of things. Because I think it's much harder for the left to demagogue on those issues. Whereas I think if the setting is, you know, those yahoos in Wyoming, they're not abiding by what the Supreme Court said, and they're the only state of all 50 to do so, it would marginalize. And my thinking here is that at some point, someone else in the federal government would bring coercion to bear on the states. Right? So if it's in an Obama administration, there would be some mechanism, the Department of Justice, I don't know who, that would eventually get you guys to back down. And I don't know if your governor is up for a fight, I don't know if your attorney general is up for a fight. And that's the thing, right? And the laughter is suggesting that they're not, right? And you know, as Donald Rumsfeld once said, you go to war with the army you had. There now doesn't. You want to get that kid. You actually know something. Yeah, I know. When it comes to Wyoming politics, I don't. You do. So let's hear from you.
Thank you. Just for my clarification, are you actually, in that answer, are you addressing the interposition nullification argument? And the reason I ask that is because I come from a very conservative district, thankfully, praise the Lord. But I do get hit with that question quite often, and I do see some of those challenges. And of course, then we could get into a whole Article 5 question, which I know that that's not why we're here. But is that what you were addressing right there, the idea of interposition and nullification?
So, I mean, I don't think so directly. I mean, I think what I'm suggesting here is that the Supreme Court is the last word only on the litigants that are parties to the case before the Supreme Court. And then the precedent the Supreme Court sets is something that you have to decide whether or not you're going to accept that as binding. Lower courts are bound by Supreme. So within the judicial branch of government, the Supreme Court is supreme within that branch of government. But that doesn't mean that the Supreme Court's interpretation of the Constitution is binding on the President's interpretation or on Congress's interpretation. So the Supreme Court keeps saying you don't have authority to make pro-life laws. Congress can keep saying yes we do and keep passing pro-life laws. And if the court keeps striking them down, Congress can keep reinstating them. I mean, that's the back and forth that takes place. And that they don't have to, I mean, the idea where, sometimes you hear Nancy Pelosi say, well, we'll have to wait for the Supreme Court to tell us if it's constitutional or not. That is totally punting on their obligation, right? They take an oath to uphold and defend the Constitution, and that means that it's not just something for the Supreme Court to do. Each and every one of us has a vested interest in defending the actual Constitution, not just what, 5 out of 9 justices say it should mean. Does that make sense?
Yes.
Yes.
Along that line, my understanding, first of all, the Constitution is a system of checks and balances. There's one check from the Supreme Court that, to my knowledge, has never been used, and that is, for example, in this case, if the Congress could actually say, Supreme Court, you cannot judge on homosexual cases anymore.
Never used since Reconstruction.
It's never been used.
It's been used in Reconstruction for more than 100 years.
Okay.
So the jurisdiction stripping, the problem with that is that it would leave in place all the prior cases. So my understanding of how jurisdiction stripping works is that you would be going forward, you don't hear any more cases about marriage, for example. But that would mean all of the decisions they've already rendered are now set in stone, because they can't reconsider them. I would say that with the best litigations, and again, I'm not a lawyer, so take it for what it's worth, but my thought would be Kennedy's opinion on this is rife with the phrase, new insights into marriage. I would say let's continue collecting the data, let's continue doing the social science. We can then present evidence of what happens when marriage is redefined. It's not a good thing. 20 years from now, maybe the state of Wyoming or the state of Texas says, we want to reinstate real marriage in our state. We now have new insights and new evidence and new data about why it matters and why a genderless regime of marriage doesn't promote the common good. And we are now reinstating that law. They pass it. Someone then sues and says, no, 20 years ago, the Supreme Court settled this issue. They then defend themselves saying, well, actually, no, here is the new evidence that we're presenting. It all will then depend who are the judges that hear the cases, who are the justices of the Supreme Court. That's what's taking place on the abortion. It means at first, we started with Born Alive Infant Protection. The Born Alive Infant Protection Act says, well, what about the child who survives the abortion procedure and is born alive? Can the technician then kill that child, or does that child have a right to life? Is the right to an abortion the right to an effective abortion, or what are the limits? Then it was the Partial Birth Abortion Act. And the first time that went to the Supreme Court, they struck it down. It went back a couple years later, and it was upheld. Now we're looking at these 20-week bills, we're looking at fetal pain bills, fetal heartbeat bills, we're looking at ultrasound bills, a variety of ways of just slowly chip back laws. And what happens is the state houses pass the law, someone then sues saying, oh, no, that violates Roe v. Wade, or that violates Griswold, that violates Planned Parenthood v. Casey, and then it goes up and it gets litigated, and they make the best arguments they can for why it doesn't violate the actual Constitution or those precedents. It strikes me that something like that's going to have to take place. And it's hard to know what exactly that'll look like until we have the new evidence, the new kind of way of making that case. Yeah, right there.
Thank you. Take you back just a little bit. Using these alliances that you talked about, those who are for freedom of speech, freedom of religion, has there been successful bills somewhere else that protected it so that the tax status can't be changed, and private business can be penalized, contracts with governments can't be canceled? That's already occurred, and you're suggesting using alliances to get that accomplished?
Not on this marriage issue. That has taken place in the 3 states I mentioned, Texas, North Carolina, and Michigan. Texas on pastors, North Carolina on clerks, Michigan on adoption agencies. Louisiana took place through executive order. Kansas, it took place through executive order. So Governor Jindal, Governor Brownback issued executive orders limiting what the state governments were going to do. Otherwise, it's such a new issue that there hasn't yet been movement at the state or the local level on this issue. And at the federal level, the bill has been introduced. It has about 100 some co-sponsors in the House. It has 20 or 30 co-sponsors in the Senate. But it hasn't been marked up. They haven't had any hearings on it. It hasn't been brought to the floor. So it's kind of stagnant. I'm going to ask you time for one last question. Yep.
Would you care to comment on the recent statement from the American Principles Project, a statement calling for constitutional resistance?
Yeah, so that's what we've been.
And on the Manhattan Declaration.
Yeah, so that's what we had just been discussing, saying that they appeal to the example of Lincoln and Dred Scott, and my only thought there is that there just isn't a critical mass of people to do that. When I mentioned in the state of Wyoming, whether or not your governor and attorney general would fight for it, the laughter suggested that probably not. So that's just the thing that when I said you go to the army, you go to war with the army you have to consider who are your leaders and are they going to stand up and fight this way. On the Manhattan Declaration, I think it's wonderful. It's a good friend of mine who used to run the Manhattan Declaration. He just stepped down from that position. He's now Rubio's director of faith-based outreach. And what the Manhattan Declaration is it's a statement for Orthodox, Roman Catholics, and evangelicals. So the 3 kind of large, and by evangelicals, I think they include kind of conservative mainline. So I see the Lutherans in the audience, and I don't want to kind of leave them out. But within the United States, it's broadly Orthodox forms of Christian, so little o forms of Orthodox Christianity with big O Orthodox, Roman Catholic, and evangelical. And what they do is they focus on 3 issues: life, marriage, and religious freedom. Sounds familiar. That's those 3 issues that you guys tend to focus on. And it's something that Chuck Colson, Robert George, and Timothy George drafted, I think back in 2008, say that these are non-negotiables. We pledge to bear witness on these 3 issues. It was prophetic because in 2008 we had not yet had the HHS mandate. We had not yet had Obama's evolution on marriage. We had not yet had the Baker LaFleur, the photographer. They could foresee all these challenges in the future. So it's a statement that you can sign your name to support. You can join their email list, get periodic updates of what's going on at kind of a national level on those issues. So it's a nice kind of counterpart to what the Wyoming Pastors Network is doing on kind of informing you on those issues here in the state. The Manhattan Declaration can kind of give you an outlet to be up to date on what's going on at the national level. So with that, I think we're out of time, and I'm going to take a nap.